Calling the case number D-21-622669-C, Opipari versus Hurd. Please make your appearance for the record. Counsel, please state your bar number.
Good afternoon, Your Honor. Shaka Chrome on behalf of Mario Opipari, bar number 8116.
Ms. Hurd?
Kymberlie Hurd, self-representing.
All right. Looks like we have two motions here. First is the motion to strike. This is a motion to strike the defendant's answer and counterclaim and to disallow the defendant from calling any witness or using any exhibits for trial and for contempt and related relief. I have bad news for you, counsel. I don't have the power to grant any of that. All that power rests with the district court. So I'm happy to hear your argument on the matter, but I'm inclined to suggest that I would deny the motion without prejudice and allow you to file it in front of the district court because the district court's the only one who has that power.
We discussed it at the last hearing, so it's just for the protective order that we're here. But thank you.
Okay. All right. So I will, for the record, deny that motion without prejudice. Now, the second motion is protective order regarding the subpoena that was sent to the city of Henderson regarding the plaintiff's employment records from back in 2017. And Ms. Hurd, when it's your turn, I'm anxious to hear what claim this relates to. I pulled up the counterclaim in this matter, and the counterclaim you suggest that both you and the plaintiff are fit to be custodial parents, and so I need to understand the information that you're seeking, what it relates to. I know in your pleadings that you're suggesting that it relates to fear that you have that your child will be abused by the plaintiff in some way. I don't know that you've made the nexus between that fear and the documents that you hope to get from the city of Henderson. So I would like you to address that when it's your turn. Ms. Chrome, this is your motion. Please go ahead.
Thank you, Your Honor. Just so you're aware, I think we're up to 19 pages of a docket in this case. Ms. Hurd has sent messages on Facebook that are disparaging to my client. She's stalked him. The police has actually advised my client that if she continues, he should file a TPO. He put recording devices and trackers on his cars. She's jogged by his house, and a few weeks ago, she sat in front of the house and the police had to ask her to move. We have grave concerns that if she were to receive any information, that she would use it not for this case, but for any other purpose. But it's not even germane to what we are trying to resolve in this case. Right now, my client has sole legal, sole physical custody pending trial. The judge has advised her what she can do to work on herself so that she could, obtain some more custodial rights. She's not doing those. She has not made any initial disclosures, and we believe she should receive sanctions pursuant to Rule 37. There's a report and recommendation that became an order where we were granted a motion to compel her discovery responses. She still hasn't responded to those. In January this year, she filed a motion saying that they should have joint physical custody with my client having half the week. And when he didn't agree, then now she's brought forth this claim. And in January, she specifically said, I do not believe that he will sexually assault this child. So now to bring up this claim after failing to participate in any sort of discovery, after losing custodial rights for this child, it's just grasping at straws and not giving us any documentation to be able to use in trial at the same time. And even on her items to be produced, he asked for settlement offers and confidential information regarding the resignation. The resignation was in 2017. They did not separate until 2020. And she's had plenty of time, if she was really concerned that there was some problems with him being a father to this child, that she could have brought an emergency motion before the court. Instead, what she filed was, I think we should have joint legal, joint physical custody. So I would ask that our motion be granted and that I be able to submit a memo for fees and costs. Thank you.
Ms. Hurd? Thank you. Ms. Hurd?
Hi, do I need to address everything even if it's not relevant? Because we're here for a protection order. And the thing is that yes, he was terminated in 2017. He told me that he was terminated for officer safety. I have discovered that it's very possible that he was terminated for sexual harassment. He does have a handful of sexual assault allegations, one of them being done by my 19-year-old niece when she was living with us, and this was during that time frame. I didn't know this. This is stuff that I'm learning as I'm going through this process. He never told me the truth, and I'm hoping that I'm wrong. It says right here, she just put another production. She's asked me 4 times to produce evidence and claims, documentation, evidence in my claim that Mario sexually assaulted women. Well, that's what I'm trying to do. If he was terminated for officer safety, then it doesn't apply, and we don't go anywhere, and it doesn't mean anything. But if in fact he was terminated for sexual harassment, that very much validates a lot of the claims that these other women are making, because they're in the same time frame, and also that I think that's very relevant with the special needs child custody case. Now, this wasn't. I did have an attorney during that counterclaim. If I have to refile based on some of this, I'm learning. I'm learning the process here. I'm trying to do my best. My daughter was taken away. I feel it was unlawfully. That's not relevant to what we're talking about today. We can discuss, so I'm trying to teach myself. I'm going to classes. I'm trying to educate myself. I'm going to the law library, and I can't keep up. I've asked Ms. Crome if she could provide these in Word formats, because I know I have to type everything up. I don't have an application to be able to type it up and answer it. I actually have handwritten notes on every single one of them. She never provided that. I'm trying to work with her. I don't get any response. So I've made offers with no response, no counterclaims. I don't want to be in court. I'm trying to settle this fair, but also, again, with these allegations, I don't want them to be true. I'm hoping I am wrong, but this is one of the most credible sources and ways that I can try to back up my claims. And again, if I'm wrong, I'll be happy, and we don't need those documents. But this is the only way, and I didn't learn of this until after we were separated.
Tell me about the form in which you have claimed to the court that the plaintiff has sexually harassed women. Is that an emotion of some sort?
So I've done a subpoena to the city of Henderson.
I understand that.
Okay.
I understand that.
So what form?
Have you filed a motion? Is there a motion before the court with regard to custodial parent issues?
Yeah, we are in pretty heated, high conflict type custody right now. We have an evidentiary hearing in August.
And the evidentiary hearing is to determine permanent placement of the child in custody?
Yeah, in custody. And again, this is relevant because there's other women that have come forward. I'm hoping to not have to disclose their names. I'm hoping not to have to disclose any of this because this is not right for me.
You haven't disclosed their names to Ms. Crome?
That's part of the witnesses. So again, I just did a litigation class, and I submitted that back in end of April. So I'm trying to teach myself what I need to do. And I've gotten the correct forms, and I'm attempting to get all this that she needs, everything that she's requesting. I'm a little overwhelmed, but I'm trying.
Okay, Ms. Crome?
Thank you, Your Honor. As she said, we're trying to prepare for trial in August. This case is over a year old. She didn't bring these allegations for the past year. I don't have any witnesses. The only thing that she did provide in her opposition to this court is text messages from 2017. So again, if she thought in 2017 or even when this case originated that there was an issue, she would have brought this before the court in front of Judge Henderson. But now it's not until after, my client gets emergency sole legal, sole physical custody, after her drug test results are bad, that she's searching for anything to try and get an equal standing or something. But it's unfair to my client that, again, we don't even have initial disclosures. We don't have any witnesses. We don't have anything. And so to make these claims and then also to harass him on Facebook and coming by his house and recording him, who knows? She's admitted that she's on medication for some, depression, some other issues. I don't know what she would do with this information, and I don't think it's relevant at this point because she's waited a year to try and seek it. And for her to say she doesn't know how to provide discovery to me, she has filed so many motions because it doesn't cost her anything. She has overwhelmed my office and the court with repetitive pleadings, yet she doesn't respond to even providing us with a witness list. So I'm just asking for it to be denied, for us to receive fees, so that maybe she'll take it serious if she has to actually pay something, to keep up making these false claims over and over again, now that she's been found to be an improper parent temporarily until we go to trial.
That's not true. That was never founded.
Okay, speak to me, not to counsel,
Your Honor,
please.
that she's making, right now she's fabricating a lot. I've never been shown to be unfit. As far as I put stuff on Facebook and go by their house, there's no proof of that. She's making a lot of allegations that are hearsay and have no substantial evidence to back them up. She just comes off the top of her head with whatever she can to try to make me look bad. I do take this seriously. Right now, I'm fighting for the safety of my daughter. I feel that she is in a toxic environment. This is one avenue that I have to prove. I had an attorney a year ago. I did address this with him. And in fact, I have letters. I submitted them. They should be in the pleadings that you have that I submitted as a response. Letters to and emails from my attorney to her with these allegations and this concern. Why my attorney did not put it in a counterclaim, we were really hoping to not have to go there. But this has been something that's been of concern. It's been in correspondence between me and my attorney Jason Stoffel and Shaka back a year ago, last summer. So yeah, for her to say that's not true either. And I would request that these allegations that she's making, as far as coming up with, that they stop. Unless she has something to actually prove substantial evidence, just making these allegations, and I drive by their house, that I make posts on Facebook. I haven't been on Facebook in probably about 9 months. And that one exhibit that she did submit doesn't even have my name on it. It's supposed Facebook post that I made, but my name's not on it, and it's not date stamped. So, again, she just likes to make a lot of allegations. There's only one way to support any of these claims, and that's to get this subpoena from City of Henderson. If I'm wrong, then I have no means. If he really was terminated for officer safety, then this doesn't go anywhere. No, I can't use that. It's not related to this case, and it won't mean anything. But however, he was terminated for sexual harassment. That is very much relevant to a lot of factors in this custody case, especially a little girl that's going to be 6 tomorrow, has Down syndrome, is still in diapers, and does not have expressive verbal communication.
All right, I'm going to recommend that the motion is granted. Ms. Hurd, you've not provided me with any evidence that suggests that the plaintiff is even the subject of a sexual harassment complaint. You've indicated that you hope not to identify witnesses, but that's exactly what your obligation is under the rules. And you had that obligation to disclose those witnesses well over a year ago when you first filed this action. And I have to say that had you provided the court with information from these witnesses, I might be inclined to agree with you here that, hold on, please don't interrupt. I might be inclined to agree with you that you get to peek behind the curtain a little bit with regard to these particular allegations and to determine whether, and to test the veracity of the plaintiff, that he was terminated for safety issues and not for being someone who sexually harassed someone at work. But I can't do that where you haven't made the disclosures and you provided me with no evidentiary support for your allegation. I mean, to be clear, I wouldn't allow the subpoena to go forward. I would allow the plaintiff to obtain those documents, and I would do an in-camera review. And then if it was appropriate, I would have a protective order for the use of those documents, because that is highly personal information. But you've simply given me no avenue to assist you in that because of your refusal to participate in discovery. So I am going to recommend that the motion is granted. Ms. Chrome, I'm going to ask you to prepare the report and recommendation. I want you to share that with Ms. Hurd. I assume you have a working email that you've given to Ms. Chrome?
Yes.
Okay. And you'll have 48 hours to review that and approve its form and content or not. And if you fail to avail yourself of that opportunity, Ms. Chrome will send that proposed order into the court without your signature and without your review. Do you understand that, ma'am?
Yes.
All right, very well. Ms. Chrome, you'll have until June 1st to return that report and recommendation to the court. We will set a hearing for 1:30 on June 8th to determine if that's been accomplished. If it has, there will be no need to appear, and the matter will be taken off calendar. All right? I wish you both well. Have a good day.
Thank you.
Thank you.